Can you guys hear me? Am I connected? Oh my God. Hey, Susan. Afton, can you hear me now? Still no sound. Oh my God. Testing? Testing? Oh, you can now. Okay. Scared me. I have the court open. I just want to show you guys this because they went over a little bit of her
Likes
testimony.
to have charged Sarah Boone with assault, aggravated assault as well. Right now, we know she's only charged with second-degree murder. But in this clip, you're going to hear Assistant State Attorney Will J. talk about the state wishing they could have charged her with aggravated assault, but he doesn't go into it, but says, due to no fault of their own, the statute of limitations ran out before they had enough information about what would have constituted that. So it's an interesting exchange here. I want to play this for you. And as soon as the judge and attorneys get back in the courtroom and start doing stuff, we will, of course, take you there.
I sent the link to you, Dr. B, if you want to come up.
The initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right. And just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And there's nothing to dispute what she said he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't go, let him out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's
when the
here's
two
what the
fingers
instruction says.
came out.
If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. It sounds like both of y'all, are disputing whether or not there's a duty to retreat. Yeah. So I think I have to, based on what the Florida Supreme Court's instruction to me is to give that second paragraph. State, anything further?
No.
Defense, anything further?
Just note the objection, but I understand the culture.
Okay, all right. So the language in the red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed. And I will add in the state's proposed language, which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed
The
revisions
saltiness.
to the 3.6F on the top of page 2 of 7.
Yeah. I'd ask if the court would read it.
Sure. Okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter.
He was there this morning. He's somewhere.
That. Thank you.
Uh-oh, are we going back? Hold on. Yeah, we're back live. Hold on, guys.
So it'll read, if Sarah Boone was not committing 3, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Ketchcore on behalf of the state. Will J. for the state.
Defense.
James Owens for Ms. Boone. Tony Anderson for Sarah.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we worked through that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strikes.
Dr. Berry, I emailed you the link if you want to hop on.
Very end of 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he, she bracketed still.
I fixed that on page 16.
Then it's just that one, I think that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right. Well,
That's the issue.
I'm going to stop him really fast.
Sorry. All right, thank you. Just give us a minute to.
Hello, Dr. Barry.
Hello, hello. Glad I was able to hop on real quick.
Yeah, me too. Oh my God, I love your hair. It's looking
Thank you,
fire
thank you.
today. Nice,
Second
nice.
day of a twist out.
Love it, love it. So it sounds like we've got a little bit of trouble with the documents, so they're going to get a copy of those or get those sent out. Longest documents ever. Do you think Owens is out prepping for closing, or do you think Henderson's going to close?
I think it's Owens because I think that's why Henderson did the
Jury instructions?
Yeah.
Okay.
Because
Yes.
Owens wasn't there at all because there was a female sitting beside her.
I think that's his daughter. Henderson's daughter is there. Everyone's saying they like your hair. Wait, I got to pull you up fully so they can see it in all its glory. There we go.
Hello.
I have been watching this and Delphi crazy.
Yeah.
Okay, let me make him muted. Hang on. Here we go. I love Kranik and all of the zen-ness that he brought today.
Did you already see George's family's interview on Court TV? Oh, yeah. That was...
I did. We played it in an earlier stream. Yeah, I was excited for... Yeah.
It was very powerful.
So that reputation paragraph should be removed in its entirety, and it should be the.
And it was nice to see it before I heard the reading of the text, because then I could put the daughter with, I mean, she was very respectful, obviously, on the Court TV, but God bless her, because I don't know if I would have had that much restraint. I wouldn't have called her Miss Boone.
10, 12, 13. Thank you.
Thank you.
And I totally believe that her talking with the officers about, they call me the white blue-eyed dragon. Because that almost sounds like a compliment, or like not devil, dragon. Like,
Right.
what?
Yeah, she immediately injected race into the conversation with those guys, right? So she could be the victim and they could be the villain. But someone said there's a Pokemon or some sort of Japanese animation that has a blue-eyed white dragon.
I think Sarah made it up in her head. Like, I don't think it existed in reality. Her going from like giddy to so sad, like no ma'am.
Right.
And I'm fully convinced that she has.
If you find
more
George Torres had a
criteria
reputation for being violent, and he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
The reputation should be deleted.
Correct. I agree with you. Yes. I'm sorry. What the heck is going on?
Yeah, they presented zero evidence on his reputation.
And I'm sure she's mad about
That's correct.
Yukio.
So they're saying it's from. I think I was on the Yukio float in the parade, not this year, but last year, or not this. You know what I mean? Wait, for the Christmas Day parade.
Cool.
What does that state exactly?
Tiny Grandma says hello.
Hey, chat. I was on Uncivil Law this morning.
Oh, how did that go? How's Kirk doing? I love him.
It was just like we just did like a quick, because it was before I started seeing people today. Because
Jay, was there another line that we had
the
added
videos
to
from
the end of
yesterday
that?
broke them, understandably.
Yesterday's videos were rough.
I was so glad I wasn't live.
I actually had to go live because I was like, I can't watch these by myself, but I need to see them.
Yeah.
Okay. Maybe that's what I was making. Maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical
Did you think
capabilities.
Cacciatore's doing the
Physical
closing? 'Cause I feel like
abilities and
Owens,
capacities. Sarah Boone.
Mr.
and
J
George
had all
Torres.
this
Is that
work this
correct?
morning.
All right, thank you.
I don't know.
I'm gonna mute him really fast. They're just going through the documents because Owens is back now, but he's had all this time to go and practice, and like Mr. J's been here in the thick of things, going through these jury instructions.
And I think they're ready. I'm pretty sure. They're ready. And to me, it's clear.
Yes. I wonder though, like, am I missing anything? Because now I'm second guessing myself because it almost seems too clear, and I know there's no slam dunk case, but I'm just like, do they have does the defense have something up their sleeve?
I'm glad that they brought up the thing about his heart issue.
Oh, I missed that. What's his heart issue?
So the coroner or the forensic pathologist, she brought up he did have like artery damage or something. So being trapped in a suitcase probably didn't help. So I think the state was concerned. The defense might say that he died from like pre-existing medical issues. Yeah, 75% blockage of, and I don't know what LAD stands for, but yeah.
Google's gonna help us with LAD.
Because I think the defense tried to say, isn't that called the wife or the widow maker or something? Yeah.
Oh, left anterior descending artery.
Yeah.
Oh my God. I'm actually surprised they didn't bring that up initially, like in opening, but they didn't have all of his medical records anyway. Widowmaker. Okay. Let's go back.
And then, Judge, I've got 2 tripods. And I've got some
So this is all like
grenades. One
setup
is,
stuff, guys. Take deep breaths.
It was originally a quote by Dr. Michael Brannon.
Objection.
Okay, may proceed. What are the other enlargements, sir?
It's it's the one I tried to get in.
I hear no
an
objection.
Opening, which was the justifiable use of non-deadly force.
No objection.
No objection.
Okay.
Keep it moving.
And then, remember my reasonable doubt? I was using it for.
You've seen him?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. Defense agreed that the 3 kind of reasonable doubt charts.
He likes AIDS.
All right, very good.
And the only other thing I want to use.
We're good with their demonstrative rates during closings that we.
This part.
Okay, very good.
I've got 2 videos.
Exactly. Because I think if you were like, if you robbed someone and they died, if they had like a heart attack, I think you could be charged. Like if you're doing a
Okay.
felony and somebody, I'm not a lawyer, but I
That's
thought
fine.
that was
Sounds right,
Once
especially in
it's in
Florida.
evidence, you can
Like you're
present
sitting
whatever
out
you
in the
like.
car and somebody else is inside robbing, and that person is
We
gets
can.
murdered
What do you
inside,
think, State? You
You're-
advised an hour and a half.
even though you're in the car.
Yeah.
Yeah.
I think we both said hour and a half, but as the court knows, you can't really hold this.
that was.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
Was it 2 weeks? I feel like it was a week and a day.
Say again?
I'm not hearing any,
Okay. The only
Stammering
thing-
for-
only
Like,
thing
so
clamoring
I
from
have
the
I
state.
think Owens has
after the
done a
state
decent, like he might get some
has
business from
had their
this.
first
I think he
opening.
had a difficult case. I don't think he's
for
done.
sure.
Yeah, I think he had a difficult case. He definitely showed that he's passionate, and I think he had a difficult client because she should have taken that deal. That deal was a good deal. If I knew videos like that existed, I would not want anyone in the world to ever see anything like that. And she's just like, man, it makes he was in the wrong. And it's like, ma'am, no.
I think that's what they were arguing about. Owens is like, if you don't take a deal, they're going to show these videos that she
you're
didn't
going
care.
to jail. Like you're going, like they have a strong, like I've seen the discovery. They have a strong second degree case. I think he's verbose. I think that word came up in some trial I watched.
He's definitely verbose. It's funny. I said that
I
about
think
one
it
of
was
my
Dr.
managers.
Lewis.
He
I
was,
think it was the Dr. Lewis case. Somebody called her verbose. I think who he's defending, and he chose this. And I'm glad that Sarah has, because this would have been horrible if she had had to do this herself.
Definitely. One, she wouldn't have been able to argue as well as, because I think Owens made some salient points that on over Sarah. Obviously, she would have been arguing from emotion, and she doesn't know the law. So
I think she still would have been like, it was unintentional. Like, I think she still would have been holding to that. I don't think she would have done the self-defense with experts, and Dr. Harper knew her well. 9 times.
yes, and not having seen her videos either, like that was interesting.
I thought Dr. Harper did. So that was Dr. Warner. Dr.
Warner, who didn't see it. Okay, Dr. Harper did. I thought for some reason I thought she only read the transcript.
She only met with her for 2.5 hours, but after all of, you wouldn't need this. Like, the video to me shows more that she wasn't in danger.
Right. What's whose histories?
Captain Ivory. Oh, Owens.
Oh, he and Henderson, Owens and Henderson. I'll do a video about it. They have a sordid past with underage women. I hope his family gets to do impact statements.
I think they're prepared to. Hey, Natalie.
They really are. He probably got him at the FedEx. Isn't it like FedEx / Kinko's, or did Kinko's finally go out of business?
I could see him being kind of demanding. Like, I'm representing someone who's on trial for second degree. Like, I could see him, like, I don't know, the poor FedEx staff. Oh.
It's Benny. I don't even know what that is. Benny. We don't know, but anything is possible. I mean, they're going to get the case so late. It feels like we're not going to start till 2:30 at this rate. We might just get through closing today.
I think Florida is one of those states where they have sentencing another day. I feel like in every other case in Florida, they've had sentencing, because sometimes they do that pre-sentencing report.
Right.
There have been other cases that it was Mississippi, it was the same day.
Yes, you're right, because Charlie Adelson had to come back, like, because his mom got arrested in between when he was convicted and his sentencing. Yeah. I was thinking verdict, and I was thinking we're running too late, but yeah, sentencing's not the same day as verdict.
I love how you mentioned, and I want to say it here again, that you're trying to be at peace with, like, you're trying to not have, like, mental control, because we all have what we want, but just making peace with whatever the jury decides. It's going to be in their hands.
Yes, thank you. I trust them. I do. And I believe George is free. So I'm not, I think he's free of her.
And I don't think he would have ever left her. I think he loved her. I don't think she has the capacity for loving anyone other than herself. I haven't seen evidence of that personally.
What about if he had gotten sober? Do you think he would have seen the light?
She wouldn't have let him remember when she invited him over, the first thing she did was she got him drunk. I think he had out, like, I think she used alcohol to control him. I think he was easier to manipulate and everything, because he seemed depressed when he was drunk.
Right. Oh my God. When he was crying in the back of the car. Oh my God.
And actual tears. No, not a tear from her. He did deserve so much better.
Who was a DP case? He was a DP case.
Oh, Wade Wilson. Wade Wilson.
Oh my God, Loverboy. Okay.
Yeah.
So Dr. Brannon also, I think it was it might have been another doctor they looked up, but one of them that was involved in this case spoke during the death penalty phase. Not Brannon.
Oh,
the guy that Sarah wanted to call up.
Oh. I don't know.
I can't think of his name now. when she was looking for the neurologist, psychiatric neurologist, or it was a
I
weird
know
title.
I know who you're thinking about, and I forget. But there's nothing wrong with her brain. It's her personality, in my personal opinion,
Right.
and her choices and decisions. I don't think, and she's never received treatment for PTSD that I'm aware of.
Right. I think she was going to blame her mom and be like, "Oh yeah, this is all from my childhood, and this doctor's going to tell you, here, get up there, doc."
And that's sad. I wonder. I just because there's a part of my brain that just wonders what else, because it seemed like that she might have reported other harm in her childhood that didn't come out on her direct, because Dr. Harper wanted to talk about it and the state stopped her because it hadn't come in evidence. I think she has more stuff from childhood. Not that does not
Okay.
excuse a thing, but it would make sense that losing your parents in your late teens, that doesn't do this. Like that's
Right. Right.
there's more to the story. Um
It's been very flip-floppy for me. Once, like she started off, she can't drink, she can't get drunk, she doesn't want to get drunk, to now she's drunk and was like can remember pieces of the evening, but things in the middle she can't remember, which is not how blackouts work. It just
But
doesn't
it's
make
it's
sense. Like
it's
she
really
was
convenient, though. It is good for a pathological liar. Like, "Ooh, this is what I need to remember to not be guilty. I remember it now." Okay. Okay, Sarah.
right.
How
So
convenient.
that all
But
goes
I but
beyond.
she's because I think she was truthful that she doesn't remember taking the picture. I think that was
Oh
truthful.
yeah.
But how do you all of a sudden remember taking the videos and then you remember this magical time? I don't it doesn't make sense.
At all. What is going on over there? Are they getting copies? Yeah, she flip flopped on it. And then even in her testimony, I felt like she didn't back away from the accident part, which I thought the judge said it can't be both accident and self defense because of the Warner.
And I think
Or wait,
Owens didn't have, because they really didn't do the "if I die, I die," because I think that might have come up in one of her depositions or in her meeting with one of the experts, because the going upstairs and just going to sleep, because I thought he would come upstairs and go to bed. Like, I thought she's still saying she didn't mean for him to die, she was just too scared
right.
to let him out, which is a problem.
And she didn't call the police. She didn't call anyone to help her. She went to sleep.
Grace, I think, alcohol was a bad combination for her. In my Just based on what I've seen and heard, I think she was mean whether she was sober or drunk, but when she was drunk, it got worse. It got way worse.
Yes. Manslaughter by culpable
I hope
negligence.
the state in their closing really goes into the depraved heart, because those videos to me, it wasn't just depraved heart at the time of this incident. I don't think she loved him. She said it. She said, "I don't love you," in one of the
I
videos.
don't love you. I don't like you. And I believe every word. I believe those words coming out of her mouth.
Shanna the Banana asked, what would Sarah's diagnosis or what could potentially cause this type of person? From what the experts have said, she has narcissistic traits, and they did not give her a personality assessment. So I do think, because they were assessing her at the time of the crime, so they don't have to get to an accurate diagnosis. One of the experts said PTSD. In my opinion, I did not meet with anybody involved, but just my thoughts. I saw PTSD in George. I did not see it at all in any of the videos or things. I did not see it in her. Um, she definitely has narcissistic traits, and that was talked about by the experts. I think if they had seen more, I think the state expert likely would have diagnosed her with narcissistic personality disorder. because I think we saw his exploitation and objectification. I know.
Oh my
We
God. I'm
saw
trying to
his
make us this way and make that smaller, but I don't have it configured that way. I'm like, what are these setups I have? Sorry.
and so I think if she had had more information, she would.
State, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
1 minute left.
Yes, sir.
I worry how she treated her son if she thinks this is normal because she infantilized George and her son was an actual child.
It sounds like he was extra. Like, it doesn't sound. It's my understanding that when they saw, he just rode his bike around the neighborhood.
Let's go ahead
all
and
by
bring in our jury.
Like
So like
he
an
just,
outside accessory. Just okay.
and if they did see anyone outside playing with him, they saw George outside playing with him.
I did hear Melissa say that. Yeah, the house property manager.
Christina, that's the word I've been trying. Vengeful. that's that's what I've been holding back.
Grace Jones, yes. Crazy and
So there might be some psychopathic type traits, but we will never, because also some people just do bad. Some people are just there is no mental health diagnosis. They just did a bad thing, and they're sadistic and mean. And so sometimes we try to make things fit into the DSM-5 when really it's just you're not a nice person.
Does defense go first?
I think
Or
state
defense and then state. Oh God. Okay. Deep breaths.
Jury entering.
She's giving them notes. Her jury's coming in. I want to know if they're making eye contact with her.
So Grace Jones asked, "Isn't when someone is sadistic, isn't that a
State,
mental
recognize our
illness?"
jury.
Yes, Your Honor.
Not
Defense, you recognize
not
our jury.
always.
Yes.
Sometimes that's
Everyone
just
can
a
be seated. Thank
description
you.
of behavior.
Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and took us a while to print everything out. I'm going to ask the courtroom deputy to come forward and pass these out to you. If you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record reflect all hands have been raised. Members of the jury,
probably won't
we are
look
at the
at any of
conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. Courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. Court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out into your family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find George Torres was killed by Sarah Boone. You will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. George Torres is dead. 2. The death was caused by the criminal act of Sarah Boone. 3. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, The death of George Torres was caused by the culpable negligence of Sarah Boone. Yes? I apologize. Or, thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. Or B, the death of George Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed George Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that.
I know you have to go, Dr. Berry. Do you have any comments on, for all of us, if we get the not guilty?
So you read the Serenity Prayer earlier, and the gist of the Serenity Prayer is grant me the power to accept the things that I cannot change, the ability to change the things I can, and the wisdom to know the difference. And in this situation, we have no control. I'm not on the jury. I'm not like I'm in no way directly connected to the case. I am emotionally invested, but you want to make sure to not blur the boundaries of because so I think for all of us, we can connect. So I connect so much with George in this. I have a son, and no matter what, in memory of George, I want to continue to share the information that boys should be taught that nobody has the right to be mean to them because we sometimes socialize boys that girls being mean to you means they like you. And I think that's incredibly problematic. So I want my child to know number one, nobody has the right to talk to him in any kind of way or to put their hands on him. He also doesn't have the right to talk to others any kind of way or to put his hands on them. It's important to understand consent and boundaries. And then also for kids and teens, when my child is probably 11 or 12, I will introduce the control wheel to him, that power wheel and healthy relationships, unhealthy relationships. Because I see this in 12 and 13-year-olds where there are one person in the relationship is saying, you can't break up with me. You can't. So these patterns can start very young, and I think it's really important for people to have education and knowledge. I hope that George's family considers doing something in his honor, some type of but and that's a lot of work, so they might not. But I will continue to use my platform to to focus on his memory. So I have a stream scheduled for tomorrow, 1:15 Eastern, I think, but to just in memory of George and to talk about male victims of this type of harm. The videos of him appearing afraid and scared. I think it was a part of him that wanted to tell what was going on, but there's so much shame. And and males often experience intimate partner violence. They can experience it different. Now, females can be victims too, and there's so many resources. There's a lot out there for women. There isn't as much out there for men. I thought the officers were incredibly rude at times. I don't know, like, but they were hearing her side first, and she puts on a really good show. A really, really good show until you look at the record and you hear the 911 call where she's clearly not in any kind of danger. She could have called the non-emergency line. I'm glad she called 911 because all those are recorded. I don't
Right.
so I'm looking back. And Sarah has done this to herself. Whatever the jury decides, Sarah did this because if she hadn't recorded her torment of him, which is what I feel, she was in a pattern of recording her harming him. And that's why she recorded him in the suitcase then. Like this is what she did.
I think she
And
got joy from it. It was she got to relive it by watching those videos.
again. And I think she felt like she was the victim in those. So I think when she watches those videos, I think somehow she sees herself as the one which is like because for her to explain to the jury, he's in the suitcase trying to get out. And she said on the stand, she was hitting him with the bat saying, "Why are you doing this to me? Ma'am, ma'am?" Like, I what? Like, to like, that is gaslighting. Like, that is the definition of gaslighting. Telling somebody who's being harmed, "You're harming me. I'm actually the victim." And so, I think educating about that, but, we this is in the jury's hands. If you're a spiritual person, pray. If you're not, light your candles, sage, I don't like do
Good vibes, good energy, whatever it is. Yeah.
And, she has, in my opinion, no matter what, she has ruined her reputation forever. If for some reason she was found where she was able to reenter society at some point, her name, I think, is now there's some people that support her, blah blah blah, but I think for a lot of us, sh- she's done this to herself, and so that's where I stand. I have to get ready for my next
I know you have
appointment.
to go. Thank
I'm
you.
so
Thank
glad I
you
was
so
able to
much.
hop on
We
with you.
appreciate you. We love Dr. Mary. Yay. See you later. Ah, deep breaths, everybody. It's the jury's gonna take it home.
He or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was
There's his
necessary
family.
to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified
His
in the
brother's
use of
wearing his
deadly
Ace
force,
Hardware shirt.
you must consider
Ugh.
the circumstances at the time the force or threat of force was used.
There's his mom right
The
there with the
danger
glasses.
need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones. And had exhausted every...
Who is
Out.
acting up in the courtroom?
Whoever phone is on, get out right now. Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George
Wake up
Torres
to
had
her
committed
every
an
morning,
act
Krista.
or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
Judge, I'm missing page 10 and 11.
I am too.
Okay. We will remedy that. Thank you, sir.
He's missing.
Is it just your copy,
page
Mr. Owens?
Anybody else missing 10 and 11?
Mr. Owens, and I think Mr. J. They're going to use them in reference. They're going to reference them in their closing, I'm sure.
Mr. Owens, approach, sir. Yes, sir.
Hello, summa cum laude BSN. Welcome.
We'll bring it to you, sir. And we'll wait till I have those, sir, and we'll continue. Thank you. Thank you. Record reflect all thumbs were up.
Oh, I'm like,
Page 11, special instruction
crime scene
on battered
investigator.
spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible,
I didn't see his
you may
ex-wife. I saw
consider
the
this
brother's
evidence
wife.
to assist you in determining whether a person in Sarah Boone's
I'm glad they're all
circumstances
there, though.
would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless one, the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or two, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because
He
the
did
doubt
plead
is
not
reasonable.
guilty to
It is to the
accusations that
evidence
he hit her.
introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest and how the case should be decided. 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10 Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not.
He couldn't commit or attempt to commit a murder on anybody. he couldn't even scratch his own head.
I'm going to back it up a little bit. I just saw on my TV that they had started, so I wanted to get us there. Let me just.
Witness her to make it. Law enforcement is not legally required to ask a suspect if the defendant is found guilty. 6, whatever verdict
George Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath George Torres took in, there was less oxygen in this box. George Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because George Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs. And it reads, the killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. When the killing is committed by accident and in misfortune, doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands.
They just got
Her
ruled.
testimony was that when George Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge, 2nd-degree murder. The law informs us that to prove the crime of 2nd-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd-degree murder to be, for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial, but these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven 2nd-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is.
Merriam-Webster is going to have to add Sarah's face
includes any series of
in the
related
dictionary
actions
next to
arising
depraved.
from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays a difference in human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. ING 1062, states 17. Mr. J, may you publish states 17?
Sarah. For everything you've done to me. Sarah. For everything you've done to me. Sarah. Fuck you. Sarah. Fuck you. Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah. I can't fucking breathe, babe. Seriously. Yeah, that's when you do any choking. Sarah.
I wonder if it's Joel from Surviving the Survivor, A. Stevens. Oh shit, that's his mom. Oh my god. Did they not warn her? That's why they stopped it, to get her out of there. Oh my god, poor woman. Positive vibes and prayers to her. And she didn't even bother to turn around. Witch. The jury's noticing, Sarah. You're not helping. I skipped to the end of the video. Sorry, guys. You know what it says.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing George Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to George Torres's murder. The defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise. He is going to show you this. And this. And this. And he's going to talk in this as well about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes.
Not one witness who could say George laid a hand on her.
About what an awful, awful boyfriend George Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. He couldn't exert anything, ladies and gentlemen. George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Approach.
You know, he's been holding on. They wanted to object when he touched those posters. Yeah, I feel like it's a big deal when objections aren't opening or closing, like somebody done something. Thank you, Pamela. I appreciate you. Yeah, this is crazy. There is no justifiable. Whatever you're feeling, it's okay, guys. If you need to take a minute, step away, come back, it's all recorded. Do a little palate cleanser. You have some puppies around or babies. They warm the heart right up. She's cold. And now imagine what we know about her from these videos. Imagine how she was talking to her attorneys, like especially Bankowitz. I feel like she verbally abused him. She definitely did Hobson. And Cashman was having none of it. She tried it. Sarah tried it. And Cashman walked her right back across that line.
Objection overruled.
Not a good look for that. Oh, and it was overruled. Sit down.
No help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the the special instruction on battered spouse.
Mr. Cacciatore said he gonna put his guns out in the suit, and it looks custom. Did you guys see that vest? Go ahead. He gets his arm days in.
You heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you
Or the judge.
whether in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we've heard from 3 experts in the areas of battered spouse in this case. And I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time, she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon. for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brandon's testimony that was very critical. Dr. Brandon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brandon, include alcohol abuse. Dr. Harper should have listened to Dr. Brandon's testimony because Dr. Brandon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brandon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brandon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because George Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
His timing is impeccable. Is this going to be another video? That's what I'm saying. He decided it was guns out, suit or not. Guns was coming out today.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She will stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismissed.
dismiss this case.
Closed.
Drop it. She is not the type of person.
Good person.
She's a great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it did.
Because I love you. Whatever you want to say. God will prevail and will take us out of this situation. Love you.
Oh, I hate
Clearly,
this, and I love you to
George
death.
Torres is dominating the defendant. Clearly, George Torres is the one telling the defendant what to do. Clearly, George Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure
Court,
that
France
George
court.
Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after
No,
she
Shanna.
had moved.
The state will get a rebuttal. So it'll be
Jay.
state
You published from state 17,
defense,
IMG 1063.
and then rebuttal from the state, which we're thinking is going to be Mr. J that does the rebuttal. trigger warning. It's the second suitcase video.
It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11-12 video. But now, roughly 11 minutes later from the time that that started, you see that the makeshift coffin that he's in has been moved, and his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not George Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Kopsel and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit George Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of George Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated George Torres? And if you say, Mr. Cacciatore, I still have a doubt, well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching struggling for that way. That also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Yes. He put his foot in it.
Members of the
Thank you.
jury, it is 4:04. As I promised, we were going to
Mr.
take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. Do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All right.
What do you guys think? Does anybody want to come up? I'll put a link in there. We have 15 minutes. So for 20, oh my God. Wanted to thank you again. Oh yes, you're welcome. Thank you for being here and for being a part of the community. I appreciate you all. I loved when he showed the pictures too. It kind of took the air out of their sail, as it were, or out of the balloon, whatever that is. I'm always mixing up analogies. The wind out of their sail. Wait, what? Hold on. In what way was it comparable? Oh, because his mom cried? That's prejudicial? Sit down. Maybe they didn't know they couldn't take it. He is loud and wrong. And his mother. Okay. And that's the judge's fault? No, it's not. Let's victimize the victims. Oh my God. Sorry, guys. Let me go back. I'm in here yelling and that was my fault. Oh my God. I got too excited. Ah, good Lord. I'm sorry, guys. Sorry. We're not back yet. We're at 409. I'll play this part again. I got heated. He made me mad. Sorry. And then I'm yelling in your guys' ear. I'm sorry, guys. Ugh. He asked for a mistrial. That was the long and short of it. Oh my God. Come on.
Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions,
He played during open. Judge, I've got a motion.
Okay, may proceed.
Sarah Boone's entitled to a fair trial. I think that right has been compromised here today. I don't know who's scheduled to put the two detectives on the front row with the Torres family, the family of the victim. But they had to have known.
Jury's not in the room.
That the suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement.
Look at Sarah's face, you guys.
You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion is denied. Jury's going to be back in about
Motion
15
is
minutes,
denied.
counsel. So we'll reconvene at that point in time.
I think.
Yeah, can we clean the well from the state's materials, please? Thank you.
I think also he wanted to get it on the record, right? That somebody was crying back there, because that's not something the court reporter would have taken down. They have turned their sound off, just so you guys know. It's not me this time. But yeah, I think he just wanted to get that on the record. But that was his mother. How would his mother know? You don't know. I mean, I would have sat in and been in there crying. I'm holding back tears sitting way out in Harlem, a long way away from Florida. Like, you don't know how you're going to react in the moment. And also, it's all the emotion of what the prosecutor is saying that's coming to hit her all at once. And I believe by her bending over, she was trying to catch herself and like sit up and do it. And then she realized she couldn't. Do you know what I mean? Or at least that's me. Sometimes like my face gets really flushed. I need to bend down, fan my face, and come back up. But she has every right to make a sound, a noise. Like, how dare he? And then Sarah was sitting there so smug, like, oh yeah, they're just in here doing that on purpose to make me look bad. I'm the real victim here. You know, like, wow. Sorry, I was yelling at all of you guys. Yes, definitely got cranicked. Was sitting by her and took her out. Right. If a juror cried, then what? He must be nervous. That's what it's signaling to me. He knows his closing is not going to top what they just did. And then they got a rebuttal. And you know Mr. J is coming with all the receipts. So I just, he's scared. And he's desperate doing that. Like, and you know the rest of the family is sitting there. Like, her other son is sitting there. His wife, her grandchildren are sitting there. And you acting like, he just has no shame. No shame. Like, you're trying to embarrass them for having an honest reaction and then accusing their reaction of being manipulative intentionally, right? Like, what are you talking about, sir? Oh, wait, are they talking again? Oh, no, someone else. I'm watching a feed up here. I got one here and another one, trying to make sure we're up to date. But then I forget to unmute us. There's a lot going on. Oh yeah, definitely. And I like that Big Guns, Mr. Cacciatore, I'm not gonna call him Chicken Cacciatore anymore. Mr. Dave Cacciatore touched it because it was almost like he took ownership of it, right? And control. And we know how much Sarah likes control, and Owens by extension, because he's the twin of Sarah, apparently, her long lost elder twin. Owens has straws and is using every weak one. Well, they are a little sturdy because he was pulling them out of his ass and they were still holding on. So sturdier than I would like. But yeah, he's got to dial it down. And then I think it was just as the jury was leaving too. I wonder if they had cleared the hallway or if they could hear that. Because I know when I was on jury duty, they queued us up by the door to come in. And then we all queued up exiting the door because the bailiff wanted to wait till the last person came out, and then he met us on the other side. So it's not like you immediately, well, at least here in New York, you immediately walk out. But, excuse me, loud and wrong. And also, the mother crying, that image, that moment in and of itself is not damning to Sarah. Sarah already said she locked him in the suitcase. Sarah said that for all the world to hear. So the mom, and we all know, or it's been stipulated, that George died in the suitcase. So that is not like a manipulation tactic for Sarah. I promise you that woman goes to bed without thinking about Sarah. She thinks about her son. She doesn't need to do extra stuff. Do you know what I mean? Like the case, I'm going to say it, open and shut. It's an open and shut case. I just, listen, if somebody would have said that about my mom when they were talking about my brother's murder and then she left and I was still sitting there, it would have been a situation. I wouldn't have got myself kicked out, but it would have been a situation. You can't, it's thoughtless. A complete Karen, yes. I thought he was about to fart. He might have been farting while he was doing it, so he talked loud. Us older people know what I'm talking about. But yeah, so yeah, I can't believe he did that. Owens is toast and he knows it, in my opinion. Cacciatore ate Owens' lunch by literally using Owens' demonstrables. Do you remember Dahmer? Oh, somebody had said this that she reminds you of Diane Downs. I said that I don't know, at some time before today. It's all blurring together. She gives me Diane Down and Susan Smith vibes, except I would say Diane Downs, I don't know if she was openly racist like Susan Smith was with the black men stole her children, but the whole affect of pretend and like being perfect and being okay, she definitely reminds me of the Diane Downs. And that same sort of promiscuous behavior and controlling men, like with her, what are they, like womanly wiles or whatever. Yeah, she gives Diane, and Diane to this day is still saying she didn't do it, and that's why she's not getting parole, because she won't admit to her wrongdoing. Uh-oh, can you guys hear me? I'm touching a whole bunch of stuff, forgetting that it's all activated to this laptop. He did that hollowing yesterday when he was asking. Oh yeah, the hollering, sorry. Yes, he sure did. That's the theatrics of it though, and that he just from the very beginning reminded me of like an old Southern lawyer when you watch those movies like oh my god, A Time to Kill and all that. He just gives me those vibes, and so he's leaning into it for show. But more than anything, his family was still in there. Like he just has no regard for other people's feelings. He's all worried. And I mean, it was for the court reporter. It was for Sarah. Probably Sarah bristled or whispered or something when it happened. But it was, yeah, that was rough. And I think we only knew, well, I did, because we saw we didn't see the mom today. We saw the wife, but I saw something with his mom today. Oh, I watched the video where she was talking about she doesn't hate Sarah. But yeah, like that, how can you know how you're going to react? Do you know? Even what was the doctor, the different variables of trauma will impact you differently depending on your background, right? And so I think they use the example like a coroner may see a dead body and be able to go eat lunch, or some like a layperson who doesn't see that may not eat for 2 days, right? Because their sensitivity levels are calibrated based on what their life experience is. How would she know that? It's not like she's been through this before. Diane said it was a bushy-haired guy. My aunt was in the ER with my sister when she brought her kids to the hospital. Oh my God. And she slow walked it in. And then she was only shot in the arm. I knew it was some weird, yeah, it was the bushy-haired guy. Came out and she threw the keys. I can't even remember it all, but I know it didn't make sense when she said it. And then when she reenacted it, she had that ridiculous grin on her face. Yeah, I would guess the deal's off the table too. I think once they started closing, they probably were like, nope. I mean, they've spent a lot of time and money on this at this point. It seems pretty clear. They had their heads down and walked out. Oh, someone I'm watching another feed. I guess the rest of the Torres family walked out. That's a shame. I wish somebody would have stood up for them. I know the victim's advocate. I just don't like that he tried to shame them. Oh, you think Sarah told him to say that? Maybe, because it's something she would do, right? She would feign. Well, I'm not saying the mother's tears were fake, but Sarah would feign tears for reaction, as we know. So I feel like at the very least, he's at the very least prejudiced. He who, she might hate her now. That's true. That is true. Oh my God. Ooh, I sometimes feel that Owens is Sarah's lover. Ooh, disgusting. I agree. And you know what? It's funny you say that because somebody else in the comments said the other day, and they were right. Sarah didn't start stapling her clothing until Owens came into the picture, which is weird. She might have some weird daddy fetish or wanting to be taken care of because she has that weird dichotomy of like she wants to be a kept woman, but then she wants to be the bossy one in the relationship. I mean, I guess it can happen. I don't know that those two are mutually exclusive, but generally people tend to pick a side. I wonder what we'll never know. But once Sarah's convicted, after they do the pre-sentencing PSI investigation, I think he's gonna let Sarah have it. I hope he is in his very measured Zen vibe. Just let her know what for and how come. That's her son. She has the right to feel and show emotions. Exactly. Is she supposed to hold back her emotions so Sarah can have a fair trial? And how is it unfair if somebody's crying? I'm sure the jurors have shed some tears as well. Is that manipulation, Owens? I think the jury got a good look at SB's face, emotionless during the fracas of George's family member's exit. She didn't even look up. She just continued to write. Exactly. Because I don't know which story to go with of Sarah. So I'm going to go with if it was an accident. If it was truly an accident, for me, I would be horrified, mortified, apologizing to those people, emphatically explaining, and I would have just pled out. I mean, not that I would do it, obviously, but I just, like, she's made this whole thing about her. And in a way, it's good because I feel like it raises awareness for all men's DV and just like conniving people in general. If you have someone in your life, whether you are male, female, black, white, Asian, whatever, this is not a healthy relationship. There's nothing wrong with you. People telling you that you shouldn't feel the way you feel or what you're doing, right? That is not normal. And I know some people are like, why do you have to say it? Like, it's true. Like, when you've grown up with a lot of trauma, you don't know what normal is unless you've gone to therapy. I'm on my own healing journey. And there's a lot of things that I thought were normal because that's how I grew up, and they're not. So if your parents talk to you the way Sarah talks to George, then you are more likely to end up with a partner that does the same thing. So therapy, protect yourself. I can't ever. Oh, Betty Broderick. Yes. The Entitled. Oh my God. Oh, Owens. Yeah, I know this is going to sound weird. I don't think he's prejudiced in a malicious way. I think because of his upbringing, don't come for me, anybody in the South, that I'm not saying you're prejudiced. I think there's just a certain time, I would say he's probably also sexist. He grew up in a time where that was acceptable, do you know? And it still is acceptable to some people because I'm going to say it. There are men out here minding women's uteruses. Where you're making laws about it. So I just think he's that old school, because even how he talks to the women, right? Like when he's talking to Detective Kopsel, I just got that little lady from him. And then when he was talking to, there was someone else. It was Beck who talked to the crime scene investigator. Like, she was crazy. Like, she had a third eye. Just disrespectful in that sense. So I feel like, yeah, he has some air of, he grew up in a time where white men ruled the world. Let me say it like that. I don't think he's holding it against anyone. That's just what he knows. That's just what he's experienced. That is his lived experience, and nobody has challenged it. I never once saw a flinch when the judge or Owens yelled. From Sarah or from anybody? Because I flinched. I was over here screaming in you guys' ears because you couldn't even hear what was going on. Because I was like outraged. I used to work with kids in child protection, and my tolerance for traumatic stories is pretty high. I intellectualized and used home to cope. So I sometimes come across uncaring, but that's not true. Yeah, sometimes you have to disconnect yourself. I mean, I work in media, so I see a lot of news all day. I mean, we have news and entertainment, but we have a 24-hour news program. And so sometimes I just feel like y'all are reaching. But you have to, there's actually a term for it. I can't think of it, where people become desensitized from seeing it all the time. So what might be traumatic to one person may not be to another, or how you cope. And sometimes I get really quiet. I'm an introvert. I'm a gregarious introvert. But, our lived experiences impact how we engage and interact in the world. And so you can't discount that. Owens and wait, what with the leg? That weird leg touching moment. Oh, I missed it. Oh, when she was on the stand, that was creepy. Like, you can just have her hold her leg up. But part of it too, I think, because he's conscious of what the jury is thinking, part of it is to humanize her, right? Like, she's not this monster. She's this dainty little lady, and she's going to show you the bruise or scar on her leg. I'm still not clear on how that happened, because it sounded like she got some kind of infection, which is why she was in there longer than, but also the whole steak story sounds sus. The whole steak story. Like, can she cook a steak? Do they normally not eat? She made so much of it that feeds into my she was starving George, and he didn't want potatoes and steak. He wanted to have sex with you, girl. Really? Okay. I will boycott anyone who gives Owens a platform. My own little protest. I'm so sick of him and his interviews. He's gonna drum up business for himself, though. Good for him. He's hotmess.com. That's all I can say. Okay, one of these feeds, it's back, but it's not back in our feed. Hold on, let me just make sure we're up to date, because it looks like movement. We're at 427, yeah.
They're making their selection. Okay, thank you. All can be seated. They're making their dinner selections. So we'll just give them a couple minutes to do that. Thank you.
Oh, they're selecting their dinner. We're gonna be here. I gotta go get Sugar Bear in a little bit, but I'll stay for as long as, well, in like an hour. So hopefully we'll get through defense's closing statement. I don't think we'll get through the rebuttal in the next hour. There's Copesol. There's his brother Juan. There's his wife right next to him. Mom is not there. She was between Copesol and Juan. I believe this is the daughter of Juan and his wife. I'm not 1,000% sure on that one. But I'm going to go right over to Facebook and be nosy. How are you guys feeling? Just do a check-in. You feeling okay? Other than Owen's shenanigans? Gives us something to be mad at, though. Somewhere to target that. Oh, they killed the sound. But we're going to hold it together. I'm going to look for his children really fast. I'll show this picture. Can you guys see that? So this is his wife. This is Juan. This is his wife. I believe this is who. Let me make sure you guys can see what I'm showing you. I believe the woman here is who is sitting next to him, which is his wife. This was in 2019. They had their 15-year anniversary, so they're almost on 20, right? Oh my God, I can't count. It should be 24. It's been 4 years. Okay, let's get back to where's that? Sorry, guys. Why do I have a different angle? Wait, what? Really? He thinks it'll be decided in less than 3 hours? I don't think so. After the Robert Tellez took a day and a half or whatever, I doubt it. Why don't I hear anything? He's desperate. Jumped up. Sarah Boone has a right to a fair trial. Like, little man, sit down. He put his back into it. The videos, the one that really, really got me was when he's on the floor and she's going on about the vodka that he drank. And didn't I tell you to get away from me? And I was up at 4 and 2 people, it was enough for 2 people to have a good time. Like, and he was laying on the floor. He said, see, there they are. Oh, wait, I'm looking at this a different angle. Let me move myself. Good Lord. They were showing the family. They are not. Oh, they're watching the. Let me see if I can switch it to that one too. They're watching the Fox local feed. What is happening? There's no sound coming out. So yeah, the thing is, the Owens hopping up just tells me that his case is weak and he's trying to create drama for Sarah. He's trying to mark the record that happened. It is standard procedure in court to not show emotion. That's a rule everywhere. Oh, I did not know that. She tried. I can't blame her. She hasn't even come back in yet. So Juan and his wife have a daughter and a son. That is what I went over to Facebook to show. And I believe that's their daughter that's next to them. Also, while we were talking, I did some research. So the oldest daughter that we saw this morning on court TV is in Philadelphia, and then the ex-wife and Cookie, the younger daughter, are in Florida. So I'm surprised I don't see them in there. Cookie is young though. What does she say? Like, she's 19. I don't know if she would want to go to this. She probably doesn't want to see Sarah. It's weird. My daughter, her dad married a woman, and the woman is very jealous of my daughter, which I always thought was weird. But now, I don't know. It's the other one in the ear. Hold on. Yeah, I don't know what's going on. Is it playing? Let's check that first. So this one, here they are. That's Juan's wife, and these are his kids, but this is from 2013. So I think this is the daughter that's sitting next to him. I think she's a young adult now. And then the son there. And then his oldest daughter, she's gorgeous. She looks like a model. Let me see if I can find her again. Or can I go back to where I was before? I hardly ever go on Facebook, guys. I'm on the struggle bus right now. Oh, you know what? I can check in his friends. Here she is. Isn't she beautiful? Yeah. And she has cat vibes on there. So that's his family. They were robbed of their relative. Okay, let's see. It is 4:34. Come on, let's get this Owens, get it together, calm yourself so you can do your little doo-wop. What is this cord? That looks dangerous. I feel like I want to go in and tape it down. And also, what do you guys think now, hearing all of those videos and having Sarah in the suit? I feel like it makes her seem more stark or stern. Because I was like a little taken aback when they showed the one video when he's on the ground, right? And then he tries to grab the phone from her, and she has on like this floral nightgown. And I was like, that is not what I was picturing her wearing. But her look now matches the severity of her attitude in all of these. Although I'm sure the jury is like, girl, you were in shorts and didn't own a bra all the time, and now you're in here in a suit. But yeah. Now she's looking at pictures. If I were her, well, I wouldn't be her, but I would be sitting there praying. She's like very interested in some papers that she's probably seen 99 times. She's definitely not going to be giving Owens notes before he goes up to do his closing. So just sit and relax. Try to find some zen. It's got to be hard for her to be quiet too. I thought about that in the interrogation when she was like, George needs to have noise. I could sit for hours quietly. And I was like, even then, no, you couldn't, ma'am. No, you couldn't. But George also, they were 10 deep in the siblings. So I'm sure there was not like a lot of quiet time in the house, and they probably enjoyed it. Like you could tell my son is, well, he's not an only child, but he's 29 years younger than his sister. But he plays, like when I go to pick him up at the end of the day at daycare, he's off in his own little corner playing with trucks. Like he doesn't have to be around the other kids. He enjoys it. He's not like, oh, I don't want to play with them, but he also enjoys time with himself. So I think those are good. And so it just sounds like everything that's come together, like Sarah was forcing togetherness, because she said things like, then he would come and do what we were doing. Well, we weren't doing anything if he wasn't there and you were only two. So then he would come and do what you were doing and told him he should be doing. Do you know what I mean? Like those subtle little slips that she had. And someone had asked, was George developmentally challenged? I don't think so. I think he was drunk. But like in that one video where he was reciting like, oh, my fiance is a good woman and she has the blind and the deaf dog. I think they said bull terrier. He seemed mentally competent to me. And in a lot of the videos where he was like getting in the car, he seemed mentally competent. I will say when he was being abused, he seemed out of sorts, but he was being abused. You know what I mean? And like, he was wasted. And that seemed to be part of her game plan. Like Dr. Berry was saying earlier, like she brings the liquor. And she talks about making him a drink or the right drink to put him out. So she knew whatever it was. So between that and withholding the food, taking the bicycle back, the sharing the phone, I still didn't understand all the stuff about the porn, though. Was he actually, or am I supposed to say that on here? The corn. Was he actually viewing that? And did she consider that cheating? Like, that sounds like Grant Amato when he was having the affair with the webcam person. Like, that is not a real relationship, ma'am. I don't know. Oh, my God. The guy is still, I know, he's still in the fridge. We're going to close the break room down soon. I guess when sentencing, we'll have to move on to another trial. I don't know, though. I might have to take a break. We'll see what it is. I think I'm going to do the Courtney Clenny next. We'll see. Nothing with children. It's hard. I'm very interested in the Maddie Soto case. I've been in a lot of chats with it, but it just is, I just wish I had an arm to go back into the past and rescue her, you know? Yes, he is. Okay, he is, all these feeds are different. The one up here, he's standing. Here, he's not standing. This feed might be behind, so we should see Owens standing up shortly talking about something. Owens and Mr. J. Let me see if I can find that feed.
Is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
Okay, I have too many things playing. Hold on. They're talking about splitting. Okay, let me see if I can cue this up. They are talking about splitting the closing. It sounds like Mr. J does not want that.
I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
If
So,
it's a
do you have
discretionary
an
issue, I'll
opinion?
leave it up to you, sir, on what you want to do and how you want to present your closing.
That smells like not preparedness. Owens was out there practicing all morning. Come on now. Now they turn the audio down. Who do you guys think it's going to be? Owens and Henderson? Our high school friends who do terrible things, allegedly, to young women? Okay, sheriff's there. I think they're bringing the jury in. I hope they are. It's 4:41.
Reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Oh. I'm going to go back really fast. Who's objecting during... Or I guess the first part's already done. That's moot.
Sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
Yes, they do,
It's a
Maui
discretionary
Slick.
issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
Is Sarah sniffing Owen's armpit, girl? Back up. Who doesn't move back when someone's reaching over them? She's just like... Okay, we're going to go back forward now.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
Oh my God. Uh-oh. They killed their sound again. I think, just from my take on it, Mr. Henderson has a better grasp on the battered spouse syndrome defense. And so that's why he wants to say some closing, because he seems to have argued all of those points, even though he didn't go to the deposition or read.
Reasonable. Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Okay, so it sounds like they're going to split it. Owens is going to object when Mr. J does the rebuttal. Oh, he's standing up in this one. Come on, guys.
All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's Northwest Florida, close
The
to
girls.
Pensacola.
That's what I call my puppies.
And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The team, the defense team, is here, and we're here to represent Miss Sarah Boone.
Did he have a blackout
And we
last
feel
night? I met
confident
you.
That we're going to be able to show you why she's not dead.
This.
Okay. I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you, and then we got a couple of videos at the end. Okay, and we're going to try our best to help you make the right decision. Okay, but yeah, Milton's a small town.
Objection. Relevance.
Overruled.
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. Very small town.
Did you see that look
You didn't know
Owens
what to
gave Mr.
expect.
J?
Coming down here to Orlando.
Relevance.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
This feels like a game where you're like rattling the people before, air ball or whatever you say. He's already got him knocked off his kilter. Yeah, definitely good old boys mentality. The girls, me and the boys. He needs to retire. Damp PB&J for dinner. She deserves it. Yes, it does look. He did look
Objection's overruled.
Oh.
all I wanted to say is just since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately,
Oh my God,
this is
he
about
lit up over here.
justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you were the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. Objection. Can we motion?
Yes.
Not the things they said. It's got to be what was said on the witness stand. These are closing arguments, sir. So Mr. Cacciatore is not on trial. Mr. J is not on trial. Your girl, Sarah, afraid of 2 fingers. Got well informed about Sarah. I think so too. And I don't think the state was too heavy-handed. They weren't too takes one to know one. That it does, Perla. That it does. So I'm gonna be petty because I need a vent. Sarah's hair looks darker today. I think that means she either has product in it or she didn't wash it. Because the color has changed throughout the trial. And I don't think she's like dyeing it and then putting in dye remover. You know what I mean? It looks oily today. I hope she didn't sleep a wink last night. Oh, I don't think Detective Copsel has to stay through closing arguments, but she is doing it for the family. She's great. Yeah, I love her and all her sass. Sneaky snake and plays dirty for sure. Oh, yeah. Happy for that county that Chelsea is on the cold case team now. She can help more families get closure. Oh, is she? Good for her. Probably less human she has to talk to, too. It's so sad. He looks like a child. Yeah. She treats him like a child. Owens is still pissed. He's putting his emotions on his sleeve and he's reacting to everything the state says. Like, visually, emotionally. Okay, let me see. Because we were behind a little bit, right? Let's see if we can get us up to real time.
You may proceed. Objections overruled.
Thank you, Judge. They got their
Oh,
side.
you won that one
their
too.
Position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and
Sort
non-deadly
of.
force. But
You
either
won.
way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Objection, proper argument.
Overruled.
I don't believe
Yes.
this. Yeah, he's tricky with the words, and Mr. J and Mr. Cacciatore are holding him to account. Because at this point, it's not opening. It shouldn't be his beliefs. He should be like, the record showed you. We clearly showed you, as you saw from blah, 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 as you heard from Sarah. It's just the facts, not his thoughts, his beliefs, him coming up from Milton. I'm sure they remember the hurricane named Milton that also came along with y'all. I don't think we will. I don't know. Seeking North Node, just because it's already 4:52. He's just starting his closing. Then rebuttal. But they did order dinner, so they're planning to be there. They being the jury. Does Sarah have a curfew?
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is George Torres.
What?
The reason for the trauma is George Torres.
What evidence showed that?
From the positive things about the man that we've seen on video to the positive things Sarah Boone has testified about, to the violent monster he becomes.
They showed it
And I
again
mean
during
monster,
closing, Jay Roberts.
because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk.
I can't
I
get
don't
up.
remember. That's the gaslighting. That this young woman,
Ooh, not
vulnerable
47-year-old.
woman with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day.
The
Depending on how
vodka
it
she
started
measured every
and then
day.
how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma.
That was gross
Dr.
for
Harper
everyone to hear.
spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right. And so that's why Dr. Harper was talking about the veterans. That's what they'll do. But you got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school.
Sarah didn't have a
time,
job.
right?
What?
Time heals, right?
No.
These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. Texting, calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind. And it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes.
So why was going to bed that time reasonable, but calling the cops all the other time? That was the PTSD?
Not that. It was something I wanted to read.
Oh, 100% AK, the cat lady. He would stage something like that, so he's thinking they're doing the same thing.
Where'd that put it?
He probably wanted it quiet so he didn't have to hear her. I mean, every second of empty
Sarah Boone's
space, she
long-term exposure to
feels
abuse
it.
created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. George Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder.
Welcome, Discworld Edge
Imminent
Witch.
danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma.
Sorry about your goldfish, Lisa.
Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes out. But it may turn by, depending on his mood. I don't know if you could tell, she would try to placate him.
Objection, facts not in evidence.
Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at.
Yes,
What a
protect
reasonable
yourself.
person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, George Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect.
You got
Sarah
one thing
Boone would
right.
argue with him, talk down to him. Some would say was somewhat abusive to him.
Somewhat.
Sarah's
Sorry.
not charged with that. Sarah Boone is not charged with that. And I want to read you something.
Yeah,
on
she's
that
kind of
subject.
charged with the abuse. The abuse was depraved.
Essentially,
He doesn't. Not yet. We're waiting.
okay, I don't know where it's at.
Uh-oh.
I have to come back to it.
Well, you should have sat down and stopped doing all that hopping
Essentially,
when the mama was crying.
Essentially, what it said was eventually
He does say it in a peculiar way. Oh no, were you mad at your dog?
it's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important.
I
what
think
wanted
he
to say
went on a
was
stand
someone
your
can be
ground
mean
thing,
and angry,
right?
and hateful, intoxicated, and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has
Eventually.
committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left George Torres in the suitcase. What's the act of a battered spouse syndrome woman?
Not according to her own
She went
testimony.
up to her room, she fell asleep, or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do.
Take a deep
Real
breath.
fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used.
Good for him if that's the
I
case.
think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you got your buddies and the other guy's got their buddies and they're drinking and there ends up being an argument.
Oh, you're right.
Two of them.
Northwest.
And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend.
Yes, Henderson's daughter.
Which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes maybe armed.
He's not arguing the facts of the
Eventually,
case.
he sees the suspect, and the suspect.
Nobody was in a
reaches for his
chokehold.
waist.
Nobody had a gun.
Now, In that moment in time, that officer has to make a decision. Am I going home with my family tonight? And I asked Dr. Werner about this Vaseline thing, it's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances.
Not one
To save her
iota.
life or save herself from another one of these. I'm 63.
Flora 4, is that the choking case where he put him in a
Can't
headlock?
imagine that. I can't imagine that. Her father's not around.
Thank you, Thee. And thanks for the super chat. Oh my God. Like the guy who shot the lady because she was throwing boiling water at him. Ooh, I hadn't thought about that.
I'll get back to it. If you'll remember,
Well said, Super Kelly. Well, we do want to fly her to the moon.
Let's start with the witnesses, and then I'll talk about Sid.
Did the cop shoot an unarmed man in a suitcase?
Out of the box for the state, if you remember, it was Juan Torres, the brother. Remember that?
Yes.
It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back.
Friday. It was a week ago.
Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us.
Gamesmanship. You said it once. Just get to the point.
Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you?
No, because Sarah was crazy.
That family.
Oh my God.
The police knew what was going on. The neighbors knew what was going on.
Little Miss Pearl.
Pearl Walker came in here. 80-something years old.
She didn't see
In
it.
a wheelchair. Kevin Beck called up. She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Old. She suffers from battered spouse syndrome. Wouldn't admit it on direct. Well, maybe I don't really know. I hadn't had enough time to really see her.
She said that about
You hadn't seen the
PTSD.
pictures? You hadn't seen the 2-minute video? You seen her one time earlier this month. One time.
Well, Harper didn't say Sarah
She's
had
gonna start testifying about stuff she's never said before until she showed up in court.
PTSD only
About,
back in
well, based on what she told me, I
September.
don't think she was in imminent fear. Come on. This is a courtroom. This is a courtroom. Good thing y'all are here. Well, thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
Overrule. Keep going.
And I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. I took a bunch of notes.
Who's the bookworm?
Let me make sure I got this quote.
He was, and Dr. Warner was able to get in that he said Sarah was the aggressor in their relationship.
Can't even find it. But it was something to the effect, maybe George Torres is the battered spouse.
Yes.
Can you believe it?
Yes.
Can you believe that?
Yes.
Now you know why we're here.
No.
Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl.
You don't put your hands on anybody, sir.
You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way.
This is the chauvinistic.
When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir.
Even if he's defending himself, I'm not justified. I'm just asking for a friend.
What has the state attorney tried to do?
Objection, proper argument.
What have they done?
Objection.
What evidence have they tried to put on?
You know what they put on, sir.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used.
I'm going to go to Twitter and see if Joel and those guys are, or X, whatever, you know what I mean. I wonder how the jury is taking this.
This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
Get him. This has worked for him in the past with
We'll get back on this.
lesser opponents who just let him ramble.
Abraham
The facts are not
Marino.
on his side.
I don't know if you remember him.
Abraham, the maintenance man.
Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out and some neighbors were coming around and there were 2 or 3 neighbors sitting around. He said, Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this, Abraham Marino knew George Torres from Philly.
No, he
Okay?
didn't.
They were friends. They would talk.
They were not
at the
friends.
complex, or if Marino went to Paul's Ace Hardware or Ace Hardware, what it's called.
Objection. Facts not in evidence.
The state
Abraham
attorney
specifically said they were not friends.
notifies.
I'm going to object to reading from things that are not in evidence.
Approach.
Not in evidence. That is right. Nobody testified to that. Abraham specifically said they were not friends. He knew him from the neighborhood. He was a kid. George was a teenager, and this man was married with children. So they weren't hanging out. And he said he talked to him. Now she's laughing. Oh, if I could pop her. They would talk at the Ace Hardware because George was a manager and Abraham was a maintenance man. And so I'm sure he needed tools and stuff. You know, maintenancing. It is horrible for all male victims. Yes. And also when he was saying that, I was thinking, at least in my family, the uncles were particularly mean to the boys, telling them not to be punks and thumping him in their chest, punching him in their chest. They weren't allowed to cry. So of course they grew up with, emotional management issues, right? Had trouble managing their emotions because they were gaslit. You don't have a reason to cry. I'll give you a reason to cry, that type of stuff. So all of that messaging for little boys, I feel like that was in the 50s. That is not how we should be. Well, that's not how I'm going to. Let me just speak for myself. Y'all raise y'all children how you want to. It's not how I'm going to be raising my son. I don't think it helps anyone. It definitely doesn't help when they get in a relationship and they haven't learned to manage their emotions. There's not one video or piece of evidence that shows that he hit her. Not one. I'm a woman, but don't come and pull the whatever a woman does. Don't hit back. I don't want my son to be abused just because he's a man. Stupid Owens. F you, seriously. Yeah. And we got to pick a side, ladies. Are we for equality or not? Like, because I just remember in high school, there were girls who would hit guys, like to hurt them, thinking, well, can't hit me back. I mean, most of the time they didn't, but then you're intentionally abusing someone because of this societal norm or expectation. You can't do that. Keep your hands to yourself. Use your words. It's giving worried. It's giving hopeless to me, this guy. I mean, the facts are not on his side, but for that very reason, he should just make his points and sit the F down because he's like belaboring these things, repeating things, that don't make a lot of sense. And it's very nuanced. Like, I think us court watchers were waiting for, well, did Abraham say that or not? Because we saw that filing that the state did saying, this witness, we've located him. He said that Sarah said she was punishing George, right? If they haven't been following the case like us nosy people, I mean, which they shouldn't have because they're the jury, they don't know what that means. Now he's like trying to shine a light on it. They were never friends. They can read the transcript back because that was asked specifically of Moreno, and he said no. He said it kind of indignant too, like, no, he was a kid. I told you I was with my wife. Like, he emphasized, like, he knew him from back in the day, and then they happened to run into each other at Tewa. They didn't move to Florida together. Like, dude, sit down. He didn't even know George was a tenant when he took the job. Because I believe that's how it went. George moved in there first, and then Abraham became okay, I'm sorry, I'm getting worked up. I'm like, oh my God, let's just get back to it. Deep breaths. If your case is solid, you don't have to lie. You don't have to make up stuff, is what my point is. Like, you're grasping. Put the straws back in your ass, sir. No one deserves abuse. No one should be hitting someone else, male or female. It's basic respect. I agree. I think it's hard, though, when you have parents. No judgment to you guys. There's some data to support this. When you hit your children are more likely to hit others, right? When you do, what is it called? Corporal punishment? Because they're learning the person who's bigger, stronger is the person who's right. They can't understand all that other nuance of like, you told me not to do it. I didn't do what you said. So that's why
You may proceed.
Or even if they do, then they're doing that to their partner.
4.5 years.
Not good.
Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week.
They skipped
and
over that
Simone,
part.
she said I
So
was teaching him a lesson, things got out
state
of hand,
one.
and then I fell asleep. 4.5 years later, we know he's friends with Victoria. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember
Brandon and Vinny,
Vincent,
yes.
Vincent Battaglia
Mm-hmm.
and Brandon Motes. Remember those guys? And you remember it came out in the testimony, you know, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, George Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened. Remember?
No.
But they got the
Something
dates wrong.
shook the wall.
And remember, Mr. Henderson called Deputy Copsel or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone.
No.
So they came back following
George was in the
us
suitcase still on the
27th.
23rd.
That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, can't remember now who it was.
Wasn't Brandon, because he said he never saw her again.
And, you know, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't hear anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs, as you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all.
Because she put it back together. He's acting like that's the smoking gun.
Anyway.
She had 13 hours to clean up.
I want to talk a little bit about that, but let me talk a little bit about the law on justifiable use of force. Is legal and lawful if you reasonably believe, I think we all probably all already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of George Torres.
Comment away. We're here for it.
What did she say?
It soothes us.
Salt tape. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that
Exactly, Northwest.
Torres chose to get in the suitcase. He's a grown man. That was his choice. She didn't force him in at gunpoint.
We don't
to
know.
Get into that suitcase.
Oh, maybe not at
He
gunpoint. At that point,
voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when
oh yeah, the girlfriend. That's a good point.
That seemed like a good thing.
Vinny was on the phone with his girlfriend.
Zipped him up. They're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering
No
why.
need to apologize.
But
Talk
I think
away.
the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that, when George is being videotaped, that's like her power. You know,
But he smashed the
Dr.
TV
Harper
while he
said
was being videotaped.
Sarah's words are her power. Sarah's words are her power. Physically, she's no match for George.
Right.
Physically,
Who is
she's
more
not.
credible? She outmatches him, outweighs him, outclasses him, weight class.
When she gets a chance,
Right.
to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him like it is. But she's got that video camera on, and George knows. He's being videoed.
So why didn't she just pull out the camera that night? Why'd he have to be zipped in a suitcase?
Or he loses it just a little bit. Right again. And then, of course, we got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him.
He's auditioning for
So
the
she
Olympics.
sits down, she turns on the phone.
FRN. As a
And
gymnast.
You've seen the tape. For everything you've done to me are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that.
He's trying to confuse them, I
Everything
think.
you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Thorne. She wants him for that moment to feel.
She totally changed her testimony.
She wants for that moment to feel, for him to feel how she feels, how uncomfortable, lack of control that she feels when George is violently.
Yep.
Just for a moment, she won't be able to feel it. And if you can imagine.
2 fingers coming out of the suitcase.
Approach.
Uh-oh. I heard objection, but I didn't hear the reasoning.
I think from the evidence, you can determine she was crazy. She was crazy about that. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him.
Yes, it does, A. Stevens. Yes, it does.
And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others.
Guys, don't apologize for your emotions. Just
There's
be
9
respectful
minutes
to
of
one
it.
another. But you're allowed to feel what you feel.
Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation.
Hold on.
That it's going to end.
So we all learned from George Floyd that just because you're talking doesn't mean you're fully oxygenated, right? They're saying they can't breathe, but that means their oxygen supply is compromised and you can still die from a reduction. So that just makes me sick. And I feel like George Floyd, I reckoned that with like, we needed that to happen. I don't mean he needed to lose his life, but so much changed, at least for me in corporate. But because you can talk doesn't mean you can breathe. I just had to say that. He's making me mad. Does not mean you can breathe.
So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got some, the two zippers removed or spread out a little bit so he can. So she thinks he's not being serious. But eventually he gets angry.
And it's two zippers,
he sends
two pieces of fabric.
And then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know, when they come in from work, what kind of mood they're in. Just by a couple of things, the way you just sense it, right?
Okay. I've got to get Sugar Bear. I'm going to let it run if you guys want to be here and I'll come back. But the thing is also when he is saying George didn't misbehave when the camera was rolling because he knew that, how would he know in the suitcase if the camera was rolling? That does not fit the facts that have been entered into evidence. He can't see out of the suitcase. Now you're claiming he can get his whole hand out. But I would think then he would, well, I don't even know. But I don't believe the whole hand coming out. But it sounds better that she was fearful of the hand than just the two fingers, I'm guessing. But he didn't know it was rolling. So why didn't she just keep playing the camera? I mean, rolling the camera. You know what I'm saying. Oh, my God.
Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete the phone.
Because she didn't remember she used it on him.
Tamper with evidence. Nothing. In the same spot as it was. She picks up the bat. She pokes. She pokes him hard. Trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries. And you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times.
Facts.
Remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining. And it's for support when you walk in it. She testified.
This part.
You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute.
No, she didn't, Mel. Nobody gets a concussion, a contusion from a poke.
I want to talk about reasonable doubt for a minute. Can't find the page, but I've got a book.
Oh, people are walking out. I wonder how the jury is reacting. Tell Joel that's what we want to know.
Let me find it. y'all are all looking. I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom three short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt. So I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we've recognized. If I've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction, it goes on, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide. A juror may believe or disbelieve any or all the part of the evidence or the testimony of any witness. I'll show you this before I begin. But Dr. Warner said, this is their expert again. He testified that Sarah Boone suffers from battered spouse syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with George Torres, and there's a bunch, affect their perception. Remember Dr. Brandon, Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from George, was because of George Torres. George Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is playing. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I know more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip him to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, or ex-husband, Brian Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine, right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually, she walks down. She's looking for George. Where's George? He's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. Is he on the computer? She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in a suitcase. She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, you heard her, I didn't know what to do. I didn't know, call Brian. That's her Safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. I have told her before. Call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No, she's trying to save his life. If she can. So the police get there. She knows if she told them, she fought back, she's going to be arrested. That's what happened before. What happened before? Like George has said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female that came up here first, the first one that arrived with body cam. Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, man, we're going to arrest you, and she gets a lawyer to go down there to make a statement, and the lawyer would advise her.
Objection. Facts on evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
She's not a lawyer. She didn't have a lawyer present when she made this statement. She didn't know the law. She didn't know she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but there were some things she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died. That was not intentional. She thought he was fine in there. Would he sober up? We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect was going to happen? I've got a daughter that she's about 18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt them up. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened. I don't want to belabor the point. I do want to show you. Just quickly show you the ending. Sarah Boone got stabbed. Think about that. Stabbed with a steak knife in the leg. And she stayed with him. She stayed with him. Poked between the eyes with a curtain rod. Stalked in the eye. And who does that? The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did. I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways. I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020. I think she first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with them. She talked about that Sarah uses her words for power. think her testimony, I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my personal. Okay. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did, that she diagnosed with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on. And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome that you stay trapped in it. I think another big, if you'll think about this, when Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence. Is she emotionally abusing?
Sustained.
Move strike.
Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You may proceed.
Okay. The prosecutor in opening statement, when he was talking about George Torres passing away, he started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about
Judge, we would vote.
Yes.
prosecutor said in opening about the violence, the violent episodes. It's a bunch of violent nonsense, was his statement to you, an opening statement. All this here, photographs, is a bunch of violent nonsense. You'll have to make your mind up what it is. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for George Torres not to have any contact with Sarah Boone. Okay? Court system got involved. They would have no contact with George Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. You know, some of the things he said to her. We know about how he treated her dogs. Nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, it's always around her. Part of his fear was her realizing that she had enough and to leave him for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. The judge has been giving court orders all week. I didn't stop George Torres. George Torres knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's George Torres. I want to show a couple of videos. And I want to say something to you. Shelby Andrews is going to help me. If we could dim the light.
Yes.
Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a room. I dare you.
Did you see
Yep,
him?
look at him. Look, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance, where he lost it, even though the video was going. Show the next one. Thank you, Judge. You turn it off. Can you turn it off? Ladies and gentlemen, I'm going to finish up right here. And Sarah Boone, I've gotten to know.
Objection. Proper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen. Fairly and impartially. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear and trauma, that you're to utilize in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances in using the force that she used to defend herself. I hope I hadn't missed anything. I've tried my best. Sarah Boone fought back and survived. We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Thank you, sir. Any rebuttal?
Yes, sir.
You may proceed.
Ladies and gentlemen, George Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook, and that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. He uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're going to play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed, and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owen, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. George Torres was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger, which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other two paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threat and use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival, him sticking his fingers out of the suitcase, him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of two things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presented to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it as a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out, it's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movements. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So
I love that he used Star Wars
this entire
analogy.
analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require a proof of intent to kill. Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. A person of ordinary judgment who would know is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand it. We're not going to belabor the past. Is of such nature that the act itself indicates a difference in human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you. It's second-degree murder. We do not have to prove the intent to kill. We have to. She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5 liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it. Another thing that we just haven't talked about much is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m., 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship. And listen to the way she talks. It's not splitting the bills. It's
Did he say all the
helping without
luggage?
argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in Rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiance. Instead, get away from the side of my door, you useless dog.
And she chased after him. He was going down the stairs.
I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it. What was in their lives that was preventing them from getting that suitcase to Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and
take
Tuesdays.
a week? Yeah.
The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip. Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time where she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument.
Welcome, Lisa D.
There's
Glad you protected your mental.
When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her. Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 p.m. the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different, tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can
She's
do the
watching
math.
Mr. J put the nails in her
0.015 times
coffin.
14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, there's a glitch in the matrix, 11:03 to 11:12. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions?
I think it's a
I submit
Picasso
when we
piece.
got off script,
Prints
by
on
we,
his tie.
with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were and that she believed that he was cheating on them with her. And apparently she is too with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, object.
Approach.
I liked Cacciatore's the best too, but he's doing cleanup now. Cacciatore had to do like the broad strokes. Let's keep it with Picasso. And Mr. J is going in and filling in the little spots, getting in, you know. I like the order that they did it in. I don't know what's happening right now. Sir, what's wrong? Are you done? No. Okay. Okay. You're all done? You just said no. Are you all done? Okay. Her nose is red. Oh my God, Pinocchio is in trouble. She's covering her face from the cameras now on purpose. And her back and neck are super stiff. I mean, her life is on the line, so I can't fault her for that. Owens had to, yeah, he's trying to break him up. Moving papers. Owens, this looks bad. I object. Yeah, Owens was ridiculous. Like it had no kind of like proper pacing. It was all over the place. It didn't flow. Like I think he was forgetting things, which is odd because he was out all morning, presumably practicing, because Henderson handled the jury instructions. You're right, Natalie. He does not have that much to work with. Will you guys do me a favor and hit the like button for me? It'll let other people know we're here. I think people are coming home from work and we want our tribe to find us. He did fight for her. That is 2. 1, 2, bourgeois, aka Lisa D. He did. He was a zealous advocate. Listen. And I wasn't not expecting the Star Wars reference from Mr. J. And then he went to Matrix. I dig it.
May proceed. Objections overruled.
Overruled. Down. Hold on.
Let me say it loud and clear. Battered spouse syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase after he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying, did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend.
Right, bookworm, annoyance,
all 6
and inconvenience.
We haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is George Torres's head is here. You can stand if you need. You've been sitting a long time too. His head is here. His butt is kind of down here.
Smart, getting them on their feet. Get that blood flowing.
And his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back are on his left side. You hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her 2 neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting him back. Let's just briefly talk about the experts, and we'll move on to the end. Dr. Brandon was absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out. There's countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm. That's the crux of the matter, Doc. You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power to stop him from dying, because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees, yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. Again, not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
Thank you both.
Thunderous
Members of the jury, I have
applause.
some additional instructions to read to you. If you would be so kind to turn to page 21 of 22.
There's nothing he can do for her now. I wouldn't read her note.
Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify
Very true.
or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven, beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The
I
verdict
love
form
Judge
reads, the
Koenig.
Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, case number 20-00260-3-O, State of Florida Plaintiff versus Sarah Boone Defendant. Verdict: we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024, signed, the foreperson. Final instruction, members to the jury, page 22. Instruction 3, room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means.
How are you guys feeling? Oh, let me mute him. Sorry. Okay. My little things just went dead. So I'm gonna take a break. I didn't charge them while I was gone because I was worried it would hang up on you guys. How are you guys feeling? I feel good. I feel like they knocked it out of the park. Mr. J and Mr. Cacciatore. I loved the analogies. I think he came in with the right tone at the end, right? Because I'm sure they were getting tired. He gave them an opportunity to get up. Oh, can you guys hear me? Sorry. Lord Jesus. Too much technology. Yeah, he gave them a chance to get up, stand on their feet. He gave me new part with the staircase and the suitcase. I think we all had rumblings about that because we talked. Well, those of you guys who are with me live, I was like, she's forgotten or she just hasn't read the testimony about the stairs because she excluded that from her original testimony. Oh, I'm lagging. I think I have too many things open. Hold on. I'm trying to monitor the whole wide world while I'm on with you guys. Okay, hopefully that helps. And people are coming home, so the Wi-Fi, I guess, is restricted. Yeah, so I feel like they brought it home, and I think I liked the way, like you could tell it was thoughtful and intentional, right? What Mr. Cacciatore laid out first, then they knew Owens was going to go, and then I feel like Mr. J brought George back into the picture and just went over the practicalness of what she said, right? Because the totality of the doubt that she's created is beyond reasonable. Like, she may have created some doubt here and there, but it's like the Charlie Adelson story. It doesn't make sense altogether. You had other options, ma'am. You did not have to go upstairs and go to sleep. It just isn't even believable. And when they're saying things like, oh, when I wasn't recording him, he was doing all this other stuff. But how would he know if you were recording him or not? And he's in the suitcase. Do you know what I mean? Like, did your flashlight come on? The torch, like what are you saying, ma'am? Her nose is red. Can you guys see her? Sorry. She's not looking well. Oh God, sorry. I got so much going on. They zoom back out. It's not looking good for Miss Boone. Who is this that's up close on her like that? There we go. Oh, wait, let's see what he's saying. Hold
your badge, you need to hang out.
That smirk is wiped off of her face. That's for sure. Oh my God.
We'll be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then. And I thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room. You can bring your phone with you. There's a basket that the deputy will take and collect for you. Thank you.
That eyeliner didn't do her any favors. It was, especially when she was on the stand, it was oozing down below her eye or dripping or whatever you want to call it, and way below the crease, right? After 40, you can't wear your eyeliner like that and then stretched all the way out to the side because we have crow's feet. It looked like she was playing dress up. Like she was dressing up as a teenager for Halloween at the age of 47.
There's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or their memory. So your objections are ruled. Mr. J and or Mr. Cacciatore, do you have the clean laptop for the review by the defense? While we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury? Yes, please. I'm going to go speak to the alternates and I'll return momentarily. Thank you.
He's gonna go speak to the alternates. I'm gonna mute this. We'll just keep it up but muted. Oh my goodness. I think Casey Anthony was overcharged. Northwest. We're gonna say that was in the past. We're gonna let all that go. I trust this jury. And Sarah's whole demeanor has changed. So she's getting the vibes. Even though I know she's not that self-aware, something in her aura has changed. Is giving dollar store. Yeah, it was like thick and waxy, right? It was like going down half of her eye. Ma'am, our eyelashes don't grow down there. I can remember I was in the hospital working when that came down. I told my coworkers it won't be a guilty verdict. Oh wow. They're gonna eat and then come back with the verdict. I think so too. Those 6. Is anyone tracking Joel? Is he saying which 6 went back? Is it because I think there's only 4 women. Hopefully they all went back. Did our DV survivor go back with the 6? Is she going to sit there? No dinner, PB&J. She's anxious. Look at her stomach she can't even sit up straight. She probably has to go poop. She ain't worried about no PB&J. Melting like a candle. Yes. Oh my God. You guys most of you might be too young, but when I was in high school, we used to get those red Maybelline sticks, jet black, I think it had on there. Light it up with a lighter or a match. Usually a lighter because your parents are going to smell the sulfur from the match, and then smear it on. I can't believe we ever did that. One of my sisters still does it. She doesn't watch the channel. And she's pushing 60. Ma'am, they are going to decide in the hallway before they finish their first pizza. Oh my God. I hope they ordered something better than pizza. They're going to be there till 10. I would have got some Italian, some Indian. Somebody said maybe Mediterranean. I saw in the chat. Yeah, I would have ordered something nice. and something that I can eat with my fingers. Like I just would like that tactile feeling, licking my fingers, bringing my fingers to my mouth. Like that would be soothing for me than trying to sit there and like navigate probably a paper, a bamboo or a plastic spoon. The fake cigarettes. Oh my god, I remember those too. I was little when I always had that. Everybody smoked back then. I'm like all the adults. So the little kids, some of them, one of the brands had where you blow it and it's like a little white powder that comes out. And then another brand had a red tip, but it was always the same. So like if your parents smoked, you're like, that's not how cigarettes burn. But yeah, I remember those. The lip liner, eyeliner, and you use them. You can at 28, but wait till you hit 40 and those crow's feet start coming in. 5 women, 1 man, I think. Okay, thanks, Tony. So then I know our DV victim was a woman, so she's back there then. I felt good. I feel good the way that the state represented George and fought, defended his name. Obviously they were in a toxic relationship. Like there's no shame in that, but it was not a relationship where Sarah was the righteous one, which is what she was trying to paint. And I felt like the state clarified that. They didn't get up there and pretend he was a candidate to be Pope. But they also didn't just like let the foolishness stand. Wait, say what? Sarah's going to look for a weak inmate to control. Oh my God. Although her friend who came into the chat one time was there, she said Sarah cleaned up after other people for money. Like she would do their laundry and clean up their bunk area for money. So I don't know. White powder and candy cigarettes. Yes. Sorry. Did I say something else? Was that me? Oh, you're clarifying your other statement. Yeah. The white in the yes. Wait. Yeah, those are my favorite because, like I said, my mom and my stepdad smoked, and so I was like, it doesn't stay red like that the whole time. It has to burn. I did that I'm a few years older than you. I graduated in the 80s. I graduated in 89. What is attorney recall time when verdict is rendered? Hope not an hour. I don't know. The judge, they've turned off the camera. Usually the judge will say, make sure the JA has your phone number. He might have said it when the mics were off. But I would say no more than an hour. Based on my experience as a true crime tracker, I've not seen it be more than an hour. Because the judge and the court people have to like verify once the jury says they have a verdict and verify it's filled out correctly and all that, and then they'll contact the lawyers. What was it in Charlie Adelson's? Was it like they had like 15 minutes? Everybody was running over there. I remember Charlie came in. He didn't have, I think they took it or they told him he didn't need it, but his tie and his belt were off and he was still shackled, like fully shackled. So I think they knew, oh yeah, he was going to be guilty, or at least the staff had a sense. All right, I'm going to hang out with Sugar Bear. Thank you guys for hanging out with me. Oh, goodness. We're going to go make dinner. Yeah, you're going to help me make dinner? Please, you guys, eat if you haven't eaten. If you're in the mood to eat, or try some bone broth. I think I'm going to heat up some beef bone broth for myself. But yes, take care of yourselves. I feel like Mr. J and Mr. Cacciatore did the Torres family proud. Yeah, I'm excited. I think Owens did the best with what he could have. Like Sarah, I don't think she'll be able to claim ineffective assistance of counsel. So yeah, we have to let them eat first. Jury is probably starving. Yeah, they're gonna eat for probably hopefully an hour. And then yeah, I'm sure they're starving. Oh my god, because they had like an early lunch too, like super early. Anyway, I will. If anything happens, I might come back on here. We'll see. It's Friday, and I usually hang out with him a little later than usual. So we'll see what he's up for. Thank you guys all so much. Please take care of yourselves and your health too. If you're in a bad relationship, consider exiting it. Okay, I'm not trying to preach, you guys. I'm trying to be supportive. If it's not coming across that way, blame it on my head and not my heart. Talk to you guys later. Toodles. Thank you.